Stanford University.
Welcome to EE380, Spring 2010-2011. I'm Andy Freeman. The other lecturer is Dennis Allison. Assignments, as always, done online via EE380.stanford.edu. Last week, we started a bit of a batch of IP talks with copyright, and Richard Stallman, for those of you who came last two evenings, was here at Stanford talking about intellectual property in general, free software, etc. However, there's lots of other forms of intellectual property besides copyright, such as trade secrets, trademarks, and the subject of today's talk, patent. Each works somewhat differently, covers different things, has different terms. Patents are particularly interesting because the law is more volatile with regards to them. Copyright terms, they get longer, and then the penalties for infringing get worse, and the sort of cruft around determining infringement and all that sort of stuff grows over time. New Zealand had an interesting change recently. But other than that, it's relatively stable. That's not true of patents, which gets us today's talk. I mean, patents, what is even patentable, has gone through various revolutions. So, as I said, today's talk by Jim Bessen will go into some of those changes and where it's likely to go, and more important, what it actually means for us.
So, software patents are controversial, to say the least. If I imagine Richard was here, you probably heard about that. But for a variety of different reasons, people have a number of different critiques about software patents. You can raise issues about, I think Richard argues that they're immoral, that they restrict freedom. Other people take much more limited things, that they're just not a good idea, that they're not necessary. I'm going to talk I'm an economist, so I'm going to talk about them in a narrow framework about whether they work well as a property system. That might sound like I've already given away the game. This is an argument I make in a book with Mike Moyer. But the point of doing it, well, it's twofold. One is a property system allows us to actually measure some things about software patents and their effects so that we can quantify the debate. And the second is, if this is probably the most conservative metric you might want to use to evaluate software patents, if it turns out that software patents fail on this basis, they're going to fail on every other criterion as well. So the idea of property is that property creates economically positive incentives that are socially beneficial. Incentives to invest in creation of new innovations, incentives to trade, to contract, to finance. And when the property system works well, it does those things. Unfortunately, property can fail. Any kind of property can fail. Very often you hear ideologues in the intellectual property debates talk about property as if it was this perfect thing that can fail, and stronger property rights are always better, and more property rights are always better, and covering more things is always better, and that's not simply true. And in the book we look at various sorts of property rights, for instance, over natural resources, and there are, in fact, quite a few areas where property rights are restricted or limited in certain ways, even for simple things like natural resources. So what do I mean when I say property can fail? Well, it fails to provide those incentives. So Zimbabwe is maybe an extreme example where here was this country that was the breadbasket of Africa. Among other things, it lost the rule of law. Farmers lost their property rights essentially, and Zimbabwe has been plunged into famine. In the book we give an example of another property right where this one holder had to in order to protect their rights, had to file 43 lawsuits. They settled with hundreds of other parties separately. They sent out thousands of amnesty letters. But this property right wasn't something in a tin horn dictatorship. This was a U.S. patent, number 4528643, the famous E-data patent, which was an invention by Charles Freeney in the early 80s. What the guy really invented was a kiosk in a retail store. If you wanted to, what was it, 8-track tapes they had back then? You wanted to, put some music cuts on an 8-track tape, you swiped your credit card, you put a blank tape in, you selected off of a menu, and it would download onto the 8-track tape, and you could walk out of the store, and that was his invention. Why should that cause so much problem? I'll get to that in a minute, but when there is this sort of dispute, litigation over a property right, it means it's difficult to enforce, and it also means there's this risk of inadvertent infringement, that people, third parties, can't really tell, can't avoid being subject to lawsuits, and therefore they face a risk. And that risk may be a disincentive for them to invest in innovation and do all the things that property systems are supposed to do. So it comes back to incentives, those incentives to invest, commercialize, and trade. And how does it fail specifically? The main issue that we focus on is what we call fuzzy boundaries. So here's the idea. If you are building $1 million building, you make damn sure that you own the rights to the land that building is on. You don't want to get in a situation where you've built the building and suddenly your neighbor comes over and says, whoop, it's 20 feet over and I own that portion of the land. There are very rich institutions in real estate law to prevent that kind of thing from happening. There is the title registry. You can go look things up. There are surveyors you can hire to walk the plot and actually determine where the boundaries are. And what the surveyors find is taken in court as evidence. There is title insurance so that you can get protection against that. When we go to something like the E-data patent, it includes terms like information manufacturing machine, point of sale location, material object. And in fact, there were legal battles over what these vague terms meant. Because of that, the patent had fuzzy boundaries. It was not clear. And so you have this situation when you have patents like that, where people do invest $1 million, not in buildings, but in research and development, and they have no feasible way of avoiding a situation where somebody can come along with a patent that's vague and ambiguous like this and assert it against them. So they face a risk that decreases their incentive to invest in the first place, and in that situation, patents do the exact opposite of what they're supposed to do. They actually decrease incentives rather than increase them. The point of sale location was a major football in the legal cases. District courts said, well, what does that mean? In jargon in the 80s, that was the term. They used to have cash registers in retail stores, right? And so these were replaced by computerized terminals. And so they came up with a name. They didn't want to call it a cash register anymore. There was a point of sale location, and that's where the computerized terminal was. And so here was this patent that was about a point of sale location, which to anybody in the computer industry, that meant that it was in a retail store, right? Well, the judges at the district court, they agreed with that. At the appellate level, though, they said, well, point of sale location is anywhere the sale takes place. So it could be in your office if it's, so basically this kiosk, I guess I didn't explain, this kiosk patent was extended to cover e-commerce because of these vague terms. And so they sued computer companies, they sued financial companies, they sued retail companies, anybody who was doing e-commerce. And at least as far as this term was concerned, they interpreted this to mean anywhere that e-commerce took place.
So a computer scientist might dispute that and say, well, the point of sale is the point at which the transaction occurs. And if this is on a network, it could be a machine halfway across the world, because that's where the actual exchange occurred. And so was this what they ended up with?
Well, what happens in these lawsuits, so there's this bizarre thing called claim construction in the process of a patent lawsuit. And it's one of the things where the law got a lot worse in the mid-90s. At a certain point, the judges decided that they really wouldn't allow the use of dictionaries, for instance. And so what happens here is both sides hire computer experts, paying them at least $300 an hour, by the way, and usually much, much more, if anybody's interested. And of course, they say completely opposite things, depending on who's paying the bill. And then the judges have this very arcane way of reading what's actually written in the patent and interpreting it. It's become essentially unpredictable. So there was one study by someone who is now a judge at the Federal Circuit, Kimberly Moore, who found that something like 40% of the district court claim interpretations were overturned on appeal, which says basically even district court judges pretty much don't know what the boundaries of the patent are. If they don't know, how can a computer company or software engineer know? It's a fundamental problem. So how does property fail? Fuzzy boundaries lead to disputes, which lead to a risk of litigation. The innovator who's looking at investing time, energy, and money into developing an innovation sees that risk as a cost down the road, and that provides a disincentive to invest. So the balance is one between the positive incentives that patents provide and the dispute costs, this risk. And what Mike and I set out to do in this book, and I'll connect this with software patents specifically, but we were looking at all kinds of patents, was to say, well, on the whole, how's the patent system doing? Are the positive incentives outweighing these risks? So we came up with some techniques, and I can go into them if anybody's interested, but fairly complicated econometrics. The incentive we were able to estimate the value of patents, and from that, the profits that patents would provide, and that was our incentive measure. And to measure the dispute costs, we measured how much money companies lost from litigation. Not just paying the lawyers, but all of the associated business costs. And so what we found was, in some industries, the patent system looked pretty good on this narrow metric. Now, you can make other criticisms about it, but so here in the chemical and pharmaceuticals, the blue line represents the profits, and the red line represents the litigation risk, and you can see we're doing much better. That the patents providing very, very strong positive incentives to invest in pharmaceuticals, and that's what a drug manufacturer will typically tell you. There's some good reasons for that, and as far as fuzzy boundaries go, one of the clearest reasons is that chemical structures have very clear boundaries. It's very easy to, I have this substance here, you've got this patent on a chemical here. It's very easy for a chemist to tell whether you infringe or not. It's a clear-cut case, so it's not an issue of interpreting what point of sale location means. For most other industries, though, the patent system was doing so-so. Basically, this is all other industries. Now, this is a public firm, so it's a restriction, but we made a number of assumptions in getting here, but we usually made a conservative assumptions, so the problem may be worse than what we're showing. Something happened in the mid-90s where the litigation risk just went through the roof. And we've done some preliminary work since then. It's gotten worse. Part of this is because patent litigation tripled since the late 90s, since the early 90s. Now, a very interesting thing, and we looked at the causes, and there are multiple causes, but one of the significant ones is software patents. The key lawsuit that really opened the floodgates for software patents was In re Allopat, 1994, and that's the right timing. When I say open the floodgates, here is an estimate of the number of software patents issued each year, and you can see they've gone up and are still going up at a very rapid clip. Now, there's some issue and controversy to some extent about how we define a software patent, but basically you get the same shape regardless of whichever definition you use. So If anybody wants to quibble about those things later, we can. And here are the lawsuits involving software patents. They too have gone up through the roof and are continuing to do so. They now make up, I believe it is about, I'm forgetting the figure. They don't make up a majority of patent litigation yet, but it's a very substantial minority. But I think probably the trend is the more significant thing. So a very significant part of that increase in the risk associated with litigation outside of chemicals and pharmaceuticals can be directly attributed to this increase in lawsuits. Okay, so first I should pause and say, well, what do I mean by a software patent? I'll admit I can't completely nail down what I mean, but the idea is a patent where the main novel element of the invention is in a computer program, and it's not to distinguish it from a situation where there's a computer program that is trivially attached to something that's otherwise a viable invention on its own. So why is it that software patents should have such a problem? Why do they, why is there a litigation problem with software patents? And the reason is fuzzy boundaries. The main reason is fuzzy boundaries. That there are lots of them. At this point, I think the estimate is there are something like more than a 250,000 of software patents in force. And they don't provide much positive benefit at the same time. So let me explore those a little bit. So first on the incentives. So we know we have this risk from litigation. What are the positive sides of software patents? Well, for software firms, it turns out apparently not much, because it was true in the 90s, and it's still largely true today, that most software firms don't get any patents at all. So the top line is for a broader industry class that includes computer services. The second line is just for startup firms, and by that I mean this is for public firms, firms that have been public less than 5 years. There was a survey study of software startup firms. Only 24% of them get patents. And there were studies of VC-backed software startups. In the Generation 98, one survey found 24%. In a more recent survey, the Berkeley group found 67%. So that's the only place there seemed to be software firms are actually getting significant numbers of patents. The first two rows are for public firms. The bottom two are for all firms. So it's a relatively complete sample. You want to know who's getting the patents? It's the top 10, the big patenters. Microsoft outstripping everybody, but here are the two, within the prepackaged software industry, SIC 73, 72. Those are the number of patents granted in those 2 years. What's that? Yeah, not a whole lot of them around anymore, but a lot of them have their patents. So Wang Labs, for instance, is now considered by some to be a patent troll. I mean, they're still working their patents. That's an interesting story on the side. I think that's a pattern. Another way to look at it is to say, of all these software patents, who's getting them? How many are going actually to software firms? So if we looked at the narrow definition of software publishers, 3% of the software patents went to that group. Now it's up to 10%, but the difference between the 3 and 10% is largely Microsoft and a few other firms. So, you can see Microsoft alone there is accounting for over half of the increase. If you look at the broader industry definition, still you're looking at 11% or 17%. Now the broader industry is responsible for employing 33% of computer programmers. So, this is a large industry in terms of programmers, not so much in terms of patents. Who's getting? I mean, we can look at if we look elsewhere and see who's getting the patents. It's computer companies, telecommunication companies, electronics companies, auto companies, a lot of hardware companies all over the map. They are using software patents because inventions that were formerly done in some sort of hardwired way are now being done with software. Not a big surprise. But in terms of providing benefits, so the key walkaway here is you've got software patents going to hardware companies, you've got software patents going to a small number of large software firms, but for software firms in general, most of them don't get patents, and therefore we have to conclude that they're not getting benefit from patents. So there is little incentive. All right, what about disincentives? Okay, so here's the fuzzy boundaries story. A chemical patent, the probability that patent will be in a lawsuit is about 1%. A software patent is going to be about 5 times greater than that. A business method software patent is going to be 13 times greater than that. Actually, there was a study by Josh Lerner where she looked at financial patents, and it was about 40 times greater than the average patent, the likelihood of being in a lawsuit. So as you get to these categories, you're getting into fuzzy boundaries, and you're getting a lot of litigation. So here's the 26% of lawsuits in 2002, and it's a higher number today. So it's got to be over a third of lawsuits are patent lawsuits, involve software patents today. So why is this? What's wrong with software? Maybe it's because, and some people have made this argument, well, here's this new technology, the patent office didn't really know how to deal with it. In fact, the patent office didn't hire computer programmers until some point in around 96. The courts didn't know how to deal with it. The software firms didn't know about it. Maybe it's just because it was new. Well, one way of looking at that is the litigation, how the litigation rates changed over time. So here, the red line is showing the probability that a software patent will be in a lawsuit within 4 years of issue. And that kept going up. It was getting worse. So in other words, as you would have think that by the year 2000, they've had 6-7 years of experience with it already. They've hired those programmers at the patent office. You would think things would be calming down, and they're not. They were still going up. They were going up for all patents too, but not quite as steeply. Is it because it's an intangible? That's part of it. I think there are multiple reasons why software patents are prone to litigation. One of the great things about tangible property is you know what its boundaries are. I mean, that's possession is a key aspect of property law in terms of all sorts of property. It's often difficult to, when you're talking about intangible, it's very hard to know what it is you possess. Did Charles Freeney possess e-commerce as his invention? No, he clearly didn't, but it becomes a much more difficult thing when you're talking about an intangible to determine what the boundaries of the property are. Is it because they're abstract? Well, I think that's part of it too, that software is inherently something that involves abstract ideas. It claims broad classes of things. How you interpret those classes, how you might interpret them in a legal proceeding, is a difficult problem and may be prone to abuse. So to sum up, what's wrong with software patents? Why do we have this litigation? It's because there are fuzzy boundaries on the one hand. 2, there are too many of them, so it becomes very difficult to, even if you could determine the boundaries, people have done these studies where they find that to set up a web shop, there may be 15,000 patents that you need to check to see whether you're infringing. A guy at Red Hat.
You're not supposed to. Your lawyer tells you you're not supposed to check.
It doesn't ever tell you that.
Well, you're not supposed to, you are at risk, and actually the law has changed recently. Until recently, it was the case that you faced treble damages if you read the patents. But in order for a property system to work, you have to have what's called clearance. You have to have people checking. And of course, nobody checks in this industry. Even, I ask people at Microsoft, do you do clearance searches? Well, sometimes, occasionally. And that's not to pick on them. It's a problem. Mark Rebbing at Red Hat talked about how they did a calculation once where it would, even if it cost them only $5,000 to check each patent, it would cost them $1 billion to do a clearance search on one product. And clearly, we're off by orders of magnitude. And the final thing is, it appears to be the case that software firms get little incentive, little benefit from these patents. And the reasons for that are very likely that they don't need this protection. Software firms have other ways of earning their rents, earning profits. Patents don't help the situation. So where is this going? So we have this increase in patent lawsuits. Is it just going to go up the hockey stick there? There have been a number of things in the works in the last few years that might change the story. There is legislation, and maybe this year it will actually get approved, but Congress has been dickering around with patent reform legislation for, 7, 8 years now in this round. I've lost track. Unfortunately, nobody I've talked to holds much hope that even if this law is passed, it will amount to much. So it's just been some possibly positive things have been watered down. There are some steps in it that would improve things a little bit, but I think very few people have much hope that it will have a large effect on the sort of this escalating litigation problem. More positive story in the courts. There have been some court decisions in the last few years that have really reined in some of the more egregious aspects of legal doctrine. And I'll talk about these. One of them is KSR versus Teleflex in 2007. This was about, in order to get a patent, you have to show that it is not obvious, and not obvious in a certain legal sense. As, when you talk about legal doctrines, all of these words have their own special meanings. Well, the KSR case reverted the standard by which the courts were supposed to evaluate this question of obviousness to an earlier standard that had, from a court decision in 1966, and there was some significant hope that some of the most obvious patents would now be unpatentable. Some of the most obvious, just last year, the Supreme Court ruled in Bilski about subject matter. Bilski was an invention for a financial process, basically a concept. And the court reaffirmed that the courts basically threw this out and said pretty much, this kind of patent is too abstract. Unfortunately, they didn't tell us what they mean by abstract and how to interpret that and what that concretely means. So the meaning of Bilski is going to have to get worked out, but it pretty clearly said that there are a lot of patents that have been granted on business methods and financial methods and some sorts of abstract kinds of software that aren't going to be found patentable in the future. We just don't know exactly what they are yet. There's an interesting case that we're hoping the Supreme Court will take up, Enzo v. Plera. This concerns, there's a standard, what's called the non-definiteness standard, which is the patent law statute says, you have to clearly define what the subject matter of the invention is, what the claims cover, the boundaries. The courts have sort of twisted that to mean at this point that something can only be invalidated if it's, quote, insolubly ambiguous, meaning they can only reject it if a judge can't find any sensible way of interpreting it. A lot of people, including myself, would like to see the standard be something like, if you can interpret it in more than one way, then it's ambiguous. I've tended to think that's what ambiguity means, but
Can you give an example of anything that can be interpreted in at least 7 ways?
well, when you say interpretation, of course, we're talking about legal interpretation.
Well, okay, that's number 5.
I'd have to look one up. There have been very few. I think it basically comes down to some cases where the judges basically can't figure out what the hell this patent means. I mean, that's essentially what it comes down to. So it's been.
When I'm paying $1,000 an hour, that person is going to come up with an interpretation. If you're paying $1,000 an hour, that person's going to come up with an interpretation.
Well,
Still.
it's not quite the way it works in patent law, because you can do something called being your own lexicographer, which means you can create your own definition. So that, if a person is committed to eliminating ambiguity, they're certainly able
Thank you.
to write their own definition and do that.
I mean, in practice, there have been very, very few cases where, at least on appeal, where this ambiguity has been a reason to invalidate a patent. I mean,
I'm just saying that there's only going to be, it's only valid if there's one, then there'll be no patents, because I'm pretty sure you can't write something that doesn't have at least 3 interpretations.
so I'm sorry, I was interpreting you the other way. So you're.
$1,000 an hour, I can get an interpretation.
Well, okay, but it has to be, yeah. It would have to be an interpretation that related to the subject at hand. So that may.
$1,000 an hour, I can get an interpretation. How long would it take you?
Who are you paying $1,000 an hour? I want to know.
Well, are you offering to do it for less?
For $1,000.
I
used to do it for 400.
Okay. See, the price is already going down.
You could hire 2 of him and an assistant.
Yeah.
Well, actually, you did that a little while ago. We need to inflate your price. So,
Can I challenge just good naturedly something that you have had up, and that's the chart that goes up to the right, showing the growth of litigation in the software patent area. Have you checked whether, or thought of whether that fairly tracks just the growth of the software industry itself? Because it would seem to me, when you said what's wrong with software, it might be more like what's right with software, and what's right with it.
I'm going to get to something like that in a minute. Well, you're not, let's be clear, you're not tracking the growth of software, the software industry, you're tracking the growth of software patenting. So,
Yes, but the industry is growing, so the number of suits would conceivably also grow in proportion. I mean, if we're talking about going from a $1 billion to $100 billion industry, then I would guess the number of patents are going to be, there's more incentive to litigate these patents because they're more valuable. Or you have a greater opportunity for return.
yeah, so we've done studies where we look at the hazard of litigation, controlling for things like the value of the firm and you know those sort of size characteristics. And yes, the litigation rate has been going up rapidly, even when you're controlling for that. But so there's another issue though, which is there are 2 factors in just mathematically, the number of software patents and the extent to which each of them is litigated. And the one area of hope that I'm seeing is, I showed you the curve earlier, which ended at 2000. It looks like since then, the probability of a software patent being in a suit has leveled off. Now, this is a jumpy series, so it's hard to really draw much from that. A possible and optimistic interpretation is that some of those legal decisions have had some effect on things worsening. If this probability stays constant, we still have a rapid increase in the number of software patents, and then we therefore still have a rapid increase in patent litigation.
But we have a rapid increase in software, so, you know.
Right.
And by the way, that corresponds to 2000 with an interesting event right
boom.
there, which put a lot of lawyers out of business.
Yeah.
At least a lot of clients out of business.
A lot of clients, but again, remember, a lot of those firms are not patenting. But the internet firms in particular were not patenting much. There were plenty, and there were plenty of patents banging around that have since been acquired, and the Novell patents and that sort of thing. Commerce One patents. But you know, I think the bigger story, the other response on this issue of, well, the software industry is growing is the benefits, by any of our measures, the benefits that software companies are receiving from patents aren't showing up. We're not seeing that growth. So
Maybe that's because the industry is so young. And what I'm finding is that a lot of entrepreneurs are coming out of venues like this, like Stanford, like I did 20, 30 years ago, when I went to a business school lecture that said patents are worthless because technology moves too quickly, or they don't provide any value. And so I created an industry. I abandoned my patent, and I could have had a lot of value from that patent if I'd actually not taken the advice. No offense. I mean, I think this is really interesting. But the advice I was getting is don't patent. That was a really big mistake. And I think a lot of entrepreneurs, you see software really growing. The opportunities are in software, but a lot of them are actually, I would argue, not doing enough patents. And I think if they actually did the patents that they should be doing, you'd have more of a balance here. I mean, right now you've got big corporations.
well, you would, if that were the case, you would think that the patents they do get are very, very valuable. No?
Well, they're compared to what?
Yeah.
Because when you talk about...
They don't need to be compared. We can estimate the value of a patent to its owner.
I know, but when you talk about pharmaceutical and the fact that they benefit greatly from that, they're making products, and it's well known that product patents are much more valuable than process patents. And most software involves process or method patents, not products. That's why they're not as valuable, probably.
No, there are plenty of process patents in pharmaceuticals.
There are, but those are not the most valuable ones. The most valuable ones are for products like Lipitor.
So what are you saying that, you seem to be
I'm
saying
saying that inherently, products which dominate the pharmaceutical business are more valuable patents than process patents, which dominate the software industry.
So you're saying that's why software patents aren't valuable?
I say that's why they're not as valuable.
As valuable?
Possibly.
Yeah. I would argue that, and actually I know of some research going on which is looking into the sort of the fuzzy boundary patents as it applies to pharmaceutical patents, comparing process, product. One of the big issues with pharmaceutical patents is all the evergreening patents, and where they try to, they'll start with a patent on a chemical composition, and then as it gets old in tooth, they'll add patents that cover various functional claims and processes and methods of delivery, and what you start seeing then is the litigation goes up, and the interpretation as well, the fuzzy boundaries get fuzzier. But back to you, sir. If only a small number of the most valuable software ideas were being patented, those would be extremely valuable patents, wouldn't they?
Right, which could be why your litigation and your litigation costs are going up. I mean, you could make an argument, I think, that if more software companies were getting patents, there would be less litigation because because they'd be able to defend themselves, whereas right now perhaps they can't.
Well, yeah, so you're talking about strategic patenting. So when we look at the litigation risks, though, even accounting for those sorts of things, we're finding, that's not explaining it. It's not, the size of the company, their market value.
The notion that you value a patent by the royalties received seems just wrong, because if I was going to start a computer company, a mainframe company, I'd look over at IBM's file and I'd say, I've got a problem. And I wouldn't start a company, and they're not getting any royalties for that, but they're keeping a competitor out.
Monopoly.
They got a monopoly.
I'm not saying, no, we don't look just at royalties. So there are two methods for valuing patents that we use. One is essentially renewal behavior. But there's some other, basically there are various fees that get for renewing a patent or for filing it abroad.
Yeah.
And when we see that a patent is not renewed for a $1,000 fee at a certain point, that tells us that at that point that patent is not worth $1,000 anymore.
Yeah.
The second way we look at is we look at public firms and we decompose their market value into a part that covers patents and then other sorts of assets. So we have, a measure of assets.
What's the value to IBM to not have Fujitsu and
So that-
Toshiba and
That relates to IBM's profits.
that relates to IBM's, yeah, it does.
And it relates to their renewal behavior also.
No,
So,
because the technology moves so fast with respect to mainframes that a 10-year-old silicon process patent is worth nothing, because the processes have changed 3 times.
well, we count a depreciation factor in there.
Oh, but this is a applicability factor. A patent on the construction of horseless carriages, or a convertible, or rather a horse-drawn carriage, is not very useful and has relatively little application to an automobile or an airplane. Whereas in the computer industry, patents which might relate to a machine that was built in 1950 have no application in today's technology environment.
Still, in terms of estimating value, we take into account the depreciation with the age of the patent. So we estimate that.
Okay, so patents have a lifetime perhaps right now less than the actual time necessary to issue.
Oh, absolutely. Oh, it's about half, yeah. So the patent term is 20 years from,
18 months is a good lifetime for a patent.
I mean, when we estimate it, we typically find it's more like, 7, 8 years.
For what industry?
Well, different industries, it's different, yes.
They're going to be completely different, though.
They're not, it turns out that they don't differ that much.
They must, because they're litigating in the pharmaceutical area about even extending or having settlements with the generic maker. They want every single last day they can get out of those patents.
Yeah, but on the other hand, they have lots of technology. We're talking about depreciation here. So the ones that are valuable, yes, they keep them to term, but they have lots of technologies also that go obsolete. That there was some drug idea that they thought was going to work, and it went to clinical trials and it blew up. They have a huge drop-off factor from that. It's comparable to the old mainframe technology. It's the same sort of problem.
Well, it's not the old mainframe technology. It's the mainframe technology of 3 years ago versus the mainframe technology of 6 years ago. The 6 year ago technology is almost worthless. The 3-year technology is and the 1-year technology is incredibly valuable.
Yeah, also, again, remember, a lot of this depends on how the patents are drafted and how they're interpreted. So, a 1985 patent on a kiosk in a music store is interpreted in a very important way 20 or 17 years later, 15 years later.
I might move on.
Okay.
I think so.
My interpretation here is that at least, possibly, the lawsuits are, the court decisions are making some positive difference. Where is it going? Just because the numbers are going up, things are going to get worse in terms of litigation. I suspect, though, that the reaction we will eventually solve this problem, but things are going to get worse before they get better. So, I don't know, we can get into some more details as you wish.
What are the chances of getting rid of this pile of junk?
None.
No prejudice there.
I don't think we're going to see it in the very near future. There's sort of a learning curve. So if you look at those charts of who was getting patents in the mid '90s, you had most of the major software firms were not, or were doing very little, and they were speaking against them. So Oracle was against software patents, and Adobe was against software patents back then. But they had to get patents for defensive reasons. So they brought in-house counsel and started patenting them.
Mainly to inhibit competition.
Well,
And it doesn't improve anything. It just holds things
it was also,
back.
IBM was knocking on their door and saying, we have all these patents, pay us some royalties, and if they got their own patents, then they could, next time IBM came around, they could say, well, we're not going to pay as much anymore. But what happens is, as soon as they then started accumulating their own patents, well, they started using them. So Adobe sues Macromedia, and Oracle sued somebody recently, I forget who. So you've had sort of you've gone down the wrong learning curve there. But what's also happening is sort of this problem of litigation is gradually elevating, becoming more and more significant. So you're even seeing a company like Microsoft, which is getting 50, 60, 70 lawsuits a year now, and was the most gung-ho advocate for software patents, has somewhat moderated their tone, and is very serious about patent reform in some way. I suspect as things get worse, the costs of this litigation for them have to be going up and will continue to go up as long as that curve is spiking up. And so at some point it's going to become an issue. It's going to move from the chief counsel's office to the CEO's office, and at that point we may see some more serious action.
Maybe the secret to success is to make the cost of litigation even higher.
Well, not only the cost of litigation, I mean, there's a very strong argument from economists that patent fees should be much higher. That one of the simple ways of controlling on a historical basis, they're quite cheap, and they're cheap in the U.S. compared to most other countries.
But the fees are such a small fraction of the cost of actually prosecuting a patent that the screwing with that is at the noise. Now, you'd be better off saying that patent attorneys in prosecution have to charge 4 times as much. That would affect the cost.
Patent attorneys might like that.
Well, they might, yeah. Not necessarily.
Yeah.
But it does.
Would you like into how much of this increase is due to the growth of non-practicing entities springing?
Yeah. So
The trolls.
in the 90s, when the data for our book was covered, it wasn't such a big factor, and it's boomed since then. There's still a minority, probably even a minority of software patents. So you're very heavily, NPEs are involved in software patent litigation. For a lot of these reasons of vague boundaries and whatever, that's their good business for them. So that's become more of an issue.
So I have a question about how this compares just the reason patents were invented. So I'm not as familiar with tech and patents, but I read Joel Mokyer's book on the Age of Enlightenment for economy, and he said that he describes patents as one of the powerful forces that helped the Industrial Revolution happen. And my understanding is that it helped provide, middle-level inventors a short-term opportunity to make a profit, so they get a little bit of time to profit off it before the competition comes in, and it creates that incentive. So you say that the patent term is 20 years, but the lifespan is 7 to 8 years. What's stopping us from just changing so that maybe instead of the patent term being 20 years, we can just make it like, well, you get 1 year to try and profit off, and that's the incentive advantage we'll give you.
Well, the shorter term might help. I mean, actually, Mokyer's earlier work was much more skeptical. I think most economic historians are much more skeptical about the role of patents in the British Industrial Revolution. And the main reason is very few of the famous inventors actually profited from patents then. James Watt was the exception, but you look at most of the major textile inventions, and either they did not patent, or they got a patent and it didn't help them, or they got a patent, in some cases they got a patent and got ruined by litigation.
So, Microsoft has muttered something about having 200 patents that Linux violates. And Google depends on Linux for its Android operating system, which is becoming a market leader against the Windows Phone. So what kind of considerations go on in the CEO's head, which has moved into his office now? I want to go into Ballmer's head as to whether or not to unload on Linux and Google.
I wouldn't want to predict what's going on in Steve Ballmer's head.
Or Microsoft's strategic interests. Why would they sue and why would they not?
Well, that sort of lawsuit in particular, that's probably an entirely different class than many of the lawsuits we've seen.
That's similar to Oracle suing Google.
Well, you're talking about something that's much broader. So there are lots of companies involved with Linux.
Yes, right.
You're talking 200 patents, which I've never heard of a patent lawsuit that involved anything close to that. And a lawsuit probably wouldn't. So assuming it was even true that they had, first off, they would winnow it down to the top, to the strongest few patents if they really wanted to push it. But in that situation, there would be a whole problem of strategic backlash because so many people are using Linux in different ways.
Does Google face that with Android suing Google? Does Oracle face that backlash from the Android guys when they sue Google?
No, probably not.
No?
I don't know. I really don't know. I was going to say something else. I forgot what it was, so it couldn't have been too important.
The PR value of doing that is far outweighs negatively the advantages to Microsoft of doing that. Plus, all of these other companies have their patents too, including IBM and Google.
Yeah, I mean, that's right. There are now these groups out there. If that happened, Microsoft would have to deal with a whole lawsuits directed at it as well. So it's not.
So Jim, one of the problems with software patents is that the field is very difficult to define. Software is made by combining little bits of program to produce a particular function. And everyone who programs probably uses the same bits and pieces and builds the same basic structure. There is no reasonable base for prior art. There is no mechanism for finding prior art when it exists, except for happenstance of knowing a particular piece of code that predates a particular piece of code. It's a very difficult space for something like a patent to even be defined. People have and hold patents on things that are, to their face, obvious to people skilled in the art at the time of the invention or even way before the invention. So that kind of argument against software patents has been expressed and has sort of fallen on deaf ears by the patent office. There doesn't seem to be a way to decide what's a rational software patent as opposed to a foolish, irrational one, which seems to be the general instance of issued patents in the software area. What do we do about it? This is a big problem. And if, in fact, the idea of patents is to, in fact, promote the public good, not the private good, how do you justify the assertion of a monopoly in a case where it's clearly not going to help the general advance of science and technology, which is the constitutional mandate?
Yeah, I wish I knew all the answers.
Do you have an answer?
I mean, I can talk about some things that have been suggested. Actually, Dave Kapos, who's now the head of the PTO, when he was back at IBM, put forward an idea that software patents should be restricted to the scope of what they specifically define in the what's called the written description of the patent. That one of the problems is this great broadening of scope that comes by using these broad terms and whatever else, and that would probably help.
Well, why should that be why should people be given a monopoly for using standard practice in a particular limited context? A standard practice is a standard practice.
If it's truly a standard practice, yeah, I mean, so there's this problem. If it's truly a standard practice, it shouldn't be a valid patent, period. By patent law and patent doctrine as it stands, it's the difficulty of showing that in a world where prior art is hard to define and find and...
Well, maybe that should be made require a restriction placed upon the patentee as opposed to anyone else, and the finding prior art should not be left to a 2-hour exercise by the patent office when the examiner has a moment, but require that a full, complete prior art case be provided by the patentee.
Can I just ask a question? I'm just curious how many people have actually applied for a software patent here? I mean, of those, my experience, I have a number of software patents, and it is way different than what you say. As opposed to a 2-hour examination, I've spent 7, 8, or 9 years back and forth several times a year with the examiner. My conversations by phone are sometimes just an hour each time. And if anything, I think that the prior art searches are certainly inefficient, but I would argue that the technology is there now. Google has the technology to search millions and millions of web pages. It has an entire base of software that can be searched. There's an unbelievable technology that's available to find more prior art than ever in the history of the patent system. It's not being utilized correctly, but these examiners are searching, and they're finding a lot of stuff that's completely irrelevant.
The average examiner, so the survey showed the average examiner spends 18 hours on a patent, on a granted patent. You've had your hand up for a long time.
So if I understand what you're saying correctly, part of your argument is that because so few of the software patents are issued to software companies, that there's little value in software patents for software firms. Yet a bunch of other firms are clearly getting all these other software patents. So these other firms, be they Ford Motor Company or some manufacturer of appliances or microwave ovens or something, must since they're getting these patents, doesn't that show that they see some value in it?
They do see some value, and then the question becomes: is the value? Well, then the first question becomes: is the value that they're seeing greater than the associated risk that comes with these patents as well? And so that we came up with the answer that at least since the late 90s, that's not been the case. Then the next question is the value that they're getting, that they're providing society worth the other costs and the other risks? And that's a harder question to answer. Although if you answer in the negative on the first question, then that one's taken care of. But one of the problems is that you're seeing this strategic patenting behavior where they're building these large thickets of patents, and software patents end up being a very quick and easy way to do that. I think it's more complicated than that, but that is one aspect of it.
So one of the problems is the time scale in talking about now. So if you look in, 100 years ago, you'd file a patent, it'd be granted in a year or something. It'd take you 10 years to shop it around, and you'd benefit for 10 years. Now, if you look at a startup, you'll build the startup in a scale of weeks, and you can get the patent in the scale of 3.5, 4 years is the backlog now, the last I heard. You're going to either succeed wildly, like a Facebook, and have a network effect, or be out of business in 100th the time that it takes to get a patent. Is there anything being done to, these timescales are so wildly out of sync. Some of the lawyers I've talked to say just don't bother. Like, you're going to either be rich or poor before you can even get the first iteration of talking to the patent office out of the way. Is there any...
You raise a good point.
Maybe there's not, I think you have to be a little cynical of the patent lawyers, to tell you the truth.
Well, clearly. But
they're telling you you don't need to worry about it. Maybe they don't want to worry about it.
Yeah. You know what, because they're talking about Mark Zuckerberg. You know what, if Mark Zuckerberg doesn't have a patent, who cares?
It doesn't matter.
But for every Mark Zuckerberg, there's 1,000 people who try, okay? And if you don't have a patent, you end up with nothing. And I know that from experience.
Well, statistically, again, that's not true. That the survey data, there's some good empirical evidence that software firms, including startup firms, have lots of ways of making money aside from patents, and they have done it. Quite possibly.
Yeah. But going back to the Ford thing, I'm guessing that a significant fraction of the innovation of, say, the Prius is actually software. There's control theory and that sort of stuff. And the fact that we're not doing it with levers anymore and with pumps and stuff doesn't change the fact that that is software, which, did involve significant innovation. And so if you're not dividing by the values, by the size of the software industry in doing any of your things, you're pretty much missing this stuff, because it's sort of like saying, well, the number of car patents went up in 1910, just exploded. Oh, yeah. The car industry exploded.
I should make it. The kind of patent you're describing might not be described as a software patent, even though it involves software. So there was a case in 1981 where software was used, and it was described in an invention, but the novelty in the invention was something about curing rubber, and people want to distinguish that from a software patent where there is no really innovation or anything going on other than of a trivial nature from the patent. So,
Is there a word for that?
that I know of.
The SetUID patent takes that form, roughly.
The what?
The SetUID patent, I believe. It's an early Unix patent. They say, okay, you could do this with a lever, but we did it with software, so.
Let me say that I spent most of my career before software patents came into existence, happily. I created a number of programs that came into widespread use. I was happy to see that happen. I created the first spelling checker, the first search engine, the first social networking program, the first blogging service, and several others like that, all before patents came in. I did get one software patent, which was mainly to please lawyers, and it didn't amount to much. I would really like to try to find a way to this stuff is just getting in the way of progress all over the place. We should try to find a way to get rid of it.
Yeah, but couldn't you say that about any, I mean, it's providing monopoly, so couldn't you say that about any field, actually, that it does get in the way? I think it's intended to get in the way. That's the bargain.
Yeah, if you're a lawyer, that's...
No, well, yeah, are you advocating getting rid of patents everywhere?
No, just software patents.
Yeah, but then, why should...
For full disclosure, I'm a member of the League, Board of League for Programming Freedom, which is devoted to that goal.
Okay, but why would you say that software patents worth less, or software as a property is worth less than someone who comes up with a chemical?
It's just intrinsically fuzzy.
I think it's more important about the
But
patent.
you're talking about the quality of the
Without the
patent.
patent, then why do you need the patent?
If it's intrinsically fuzzy, you're talking about quality, not merit. I mean, not just generally the merit.
Yeah, it's interesting looking at other technologies. Software is very different in that you still have, again, from the surveys that have been taken, a majority of the people who would be the inventors of new ideas are opposed to patents in this case, where that has not really been true historically.
No, I don't think that's true. There's Americans for it, inventors for reform. I mean, there's a huge number of pharmaceutical companies that, and also every university, including Stanford, is in favor of keeping patents.
I'm talking about programs. So in other words, surveys of programs, the actual individual inventors are...
Saying, okay, to be perfectly honest, that's like saying most car mechanics are not in favor of car inventions. Honestly, most programmers are not inventors. I mean, you can't lump them together and say they're all inventors. What do you think about software?
I think that actually is interesting and on point. Most software patents are not inventions, and therefore do not deserve the protection of the patent. The problem is, how do you separate the kernel of invention from everything else? And that's a difficult task. It's one that we have clearly not met. And that's why we have this particular colloquium right at the moment, is that the current patent system, in general, has a very low bar for invention and creativity, but in particular in the software area, it's exceptionally low compared to what it perhaps should be.
But also, isn't it true that the barriers to entry for developing software are also very low? So consequently, you're going to have many more, maybe. You're going to have people, just about anybody can do it. Anybody can claim they've invented something. You wouldn't find that to be true in a lot of other industries, I think.
I think that we have all sorts of people claiming that they invented amazing things, including people who should really know better. There are, as everyone who's had anything to do with the patent system knows, there are an enormous number of patents which are community jokes because they provide protection for things that are either silly or clearly within the prior art. The laser exerciser for cats and the Microsoft patent on a RFID on a front door strike me as being in that category, but there are pages upon pages of these that have been collected by all sorts of people in different places. So,
Neither of those are software, by the way.
pardon?
Neither of those is software.
Neither of those are software.
So just an interesting comment. There's a lot of studies out there that say the examiners basically only look at other U.S. patents and they'll ignore, even if you tell them something else that's relevant, they'll still ignore it. So I'm wondering if this will maybe, as we build up this useless, 20 years or so of bad software patents, eventually the examiners will have enough tools at their disposal to eventually be able to not allow anything else.
No. Most software patents do not include the software.
Yeah.
They're included as
As a
an
problem.
appendix, which is a bit of a problem.
How much of the problem is software in the sense of what programmers would think of as software as compared to business methods or whatever the other stuff might be?
Yeah, business methods isn't a large part of this. It's a substantial part, but, and then you get a lot of things which are maybe hard, a little of both. But you know, you've got all sorts of software. Again, depending on how you're counting and what you're counting. It's not
It makes about as much sense to patent software as to patent mathematical formulas. That is to say, no sense at all.
Someone try.
So your talk is titled "The Future of Software Patents." Could you give us any sort of conclusion of sort of what you think that future?
It's going to get worse before it gets better. I'm not much really, I probably mistitled the talk, sorry. If anybody feels they want, they can get their ticket money back.
Thank you very much.
For more, please visit us at stanford.edu.